Well, welcome and thanks for joining Narin. Narin, you're from Ascenta. Ascenta? Yeah, got that
Ascente.
right?
That's
Yep.
right.
Corporate and commercial law. Really appreciate your time and coming on today. And we want to garner your experience and thoughts and knowledge and all those sorts of things that in what is a bit of a hot topic in terms of what's happening in the technical space, but other spaces as well in regards to the legal aspects and components. And I've got some really interesting questions. So really appreciate you coming on. First question, how does a guy go from doing law in Australia and then going to New York and practicing law for, did I say 12 years? Is that correct?
Yeah, I think it has been 12. That would be right. That would be right. How do I go from Australia to New York?
Yeah.
Watching too much TV. I think that's probably the case of watching too much Hollywood and deciding I want to go to New York and be a New York attorney and live in the Big Apple. So that was the dream, really. And it became a reality. So right
Yeah.
after uni, really, just went to New York, did the bar exam, put my head down, became an attorney there. So that's really cool. And I still practice a fair bit. I've got clients overseas. We
All
do a
right.
lot in the US. So there's a lot of cross-border things that happen. So yeah, I kind of enjoy
How
it.
does a little bit off topic from where I wanted to go, but how does I know nothing about law, right? I've got a very minimal understanding of what happens in the law space, but I do know that the law is completely different in both US and Australia. Obviously you need two totally different sets of skills there?
They're not as different as you would think, really. So, they're all based on common law, all the British system, really. So, the statutes will change, and the US is a whole different beast. You've got 50 states, you've got, each state have their own little nuances. And it's not like we practice in every single area of law, right? So it's like you go to a doctor, you got different areas, same thing with lawyers. So we really specialize in those areas that we know. It's really commercial, corporate areas, anything that businesses do, mergers and acquisitions, employment, that sort of thing. And it's just a matter of having the right resources and the right people on the ground as well. So we've got an extensive network. Got lawyers there, and so you just call in the right expertise when you need it. I guess the good thing for us is because we've got a bit of a foothold in both places. Clients kind of like that because you can understand a little about Australia, a little bit about the US. So it works
Yeah,
well.
yeah, unique situation. I certainly don't know. Not that, as I say, I'm not in tune with the industry, but I wouldn't imagine where there's too many lawyers out there that have had experience in both countries with an extensive network. So very interesting. Mate, tell us a little bit about Ascenta, your firm, and you touched on a few areas of specialisations, but run us through some of that history and what you do.
Yeah, so I guess the center is the second iteration of the law firm that I initially started back in 2013. Yeah, so we've been in this game, I guess, now 11 years. Uh, my main area really is mergers and acquisitions, technology. Yeah, really big into that. A bit of a nerd, I guess. Yeah, that's the space that I really like playing in. Enjoy working with tech clients, and that's really where the base of our clients are. They're really tech clients. They're clients who are in financial services. That's another large group. Health technology clients and education. So those are really the four main sectors, and how we support them really is around growing anything to do with business and growth, capital raising, mergers and acquisitions, and just the day-to-day business matters, reviewing contracts, service agreements, employment matters, things like that. Really enjoy working with growth companies, and also companies who have grown and maybe they're taking the next step in their journey. I don't really work with public companies. They're different based. They have, their own strategies and they're just looking at doing different things. We love working with family groups or sole owners or business partners who've grown and we've been part of that journey. It's really exciting to see that and we get really invested in it because as they're growing, we feel we're part of it. And so when they're doing something, it's kind of exciting for us, and we're more invested in that process.
Long-term clients.
Yeah.
Yeah, right. Interesting. I want to dive deep. You mentioned technology, obviously, is one, and that's one of the reasons why we've got you on. But to hear your story, there's so much been happening in this space, and as a service provider that provides services to medical and healthcare, hospitality. These are just some of the verticals that we provide IT services to. Clients are coming to us and also other boards and what have you that I do some consultancy for, and saying, tell us about where our risk lies. And I can answer that from a cyber perspective, and a risk mitigation from technical perspective, but I certainly can't. They sort of sometimes think that we're, lawyers as well. There's been a big instance of a breach, or there's been a number of them, but one of the ones that I wanted to ask you about, and it's obviously it's a case that's happening at the moment. It may not be a case, but it's certainly in situ at the moment, so we probably don't talk to it. But there's been instances where someone walks into a venue, a hospitality venue, or it might be a medical thing, and they hand over information to a small business or a medium-sized business, and then all of a sudden it's one thing for the organisation, and we'll get to this in a little bit on how they handle risk around holding of personal identifiable information and critical information, Medicare numbers, all this sort of stuff, whether they're in healthcare or just identifiable information, licenses in other areas, and then they pass this information over to third parties because there's databases and things like that. We're getting asked a lot. Where is the risk, and obviously the end user has passed the details over to company A, and then company A's passed it over to company B with maybe no knowledge. Is this a minefield, and is this a big risk for small and medium business?
It is a risk, and I guess if we just walk back to first principles, essentially what the Privacy Act says is if an APP entity holds personal information or sensitive information, it needs to take reasonable steps to protect that information from misuse, from loss, unauthorized access, all the usual type things. So company A, the collector, essentially, is responsible. And when it hands over to, say, company B and company C and whoever else it hands it over to, it's a transfer of duties. They're saying, all right, you as a service provider, we want you to do payroll or accounting or IT, whatever it is. It's a transfer of duties. It isn't a transfer of liability. So what that really means is company A is still responsible, but company B is also responsible under the OAIC guidelines, essentially. And it basically says, if you hold it and you're processing it, you are also liable. So everyone is basically thrown into the mix. So everyone really needs to think about how they're handling that information and how they're protecting that information. The guidelines also suggest that a breach by one entity is considered a breach by all of the other entities that hold and control that information, and all of them have obligations under the scheme. So you can imagine basically it's a cascading effect. You get one that's affected, everyone else basically gets thrown in. And how the parties deal with that really often comes down to contract. And the parties, when they're negotiating the contracts, basically look at the guidelines and say, well, who has the closest connection to the clients or the information and can respond to that. I don't really like that situation. And you can imagine company B probably, as the service provider, for example, could be a bit uncomfortable if the customer, being company A that collected it, says to the service provider, well, you can't notify a regulator if there's a data breach unless we say so, for example. And I've seen clauses that say that, because that's basically the service provider giving away their ability to respond to a regulator and comply with the obligations. So you can imagine there's a lot of negotiation that happens around these contracts. And we're seeing it a lot as well, because a lot of our clients, for example, deal with overseas organizations. They're often dealing in personal information from multiple countries and have to, understand the regulations in different countries. And then they also understand that they have obligations under the various legislation to report breaches and deal with things like that. But everyone doesn't want a report to go out because there's reputational damage and things like that. So you really have to manage that process.
Yeah, it's interesting, isn't it? Because I think the work that we do with a lot of clients is sort of sitting back and going, okay, well, I often say there's every small and medium-sized business, actually, no matter how small you are, we all sign up to these platforms. Software as a service, as we call it in our industry, basically a subscription for sending emails and, these platforms that we hand customer information over to. You think we're doing the right thing in trying to provide a better service and all these sorts of things. But what we're seeing is that there's not a lot of due diligence in this process of going, okay, well, who are these people? Where is the data going? Where's that, if I hand this data over to, company B, then what are they doing with it? Because we see a cascade effect, then they've got 3, 4, 5, however many suppliers. Talk us through what companies should be doing in sort of that, is it a combination of due diligence, making sure that your terms and conditions or agreements with clients are in place? Like what can because practically a small and medium-sized business, even some big entities, every single time can't go out and seek legal advice.
No,
obviously they're generally seeking legal advice when something goes pear-shaped. Talk us through what that people can do when, to try and reduce the risk.
Yeah. So firstly, you probably want to do a little bit of due diligence. I mean, that's an obvious answer. How you would do that, I think it's probably a good idea to create potentially a checklist, and there are various checklists available online with the OAIC as well, where you can ask service providers about how they protect information, where the information is going, because as a business, you're also going to have a privacy policy that's going to have to disclose where information is going, essentially. You want to deal with probably reputable companies, so doing a little bit of due diligence online, really, if you don't have many resources, looking online, there are various platforms where you can get reports on companies and obviously reports about data breaches. If a company is in Australia, there are registers where data breaches are recorded, and so you can do a little bit of due diligence that way. But as a small business, that's probably as far as you can go in terms of DD.
Right.
You can then move on to your contractual perspective, and in that respect, you probably want to ensure that the contract has various areas that it covers. So firstly, that the third party has data protection systems, for example, that satisfies your standards or your requirements or your policies, that you are notified of a breach immediately or a suspected breach as well, that you have an action plan potentially with that third party. And not all businesses will need this. You should really look at whether it's necessary based on the services that are being provided. If it's you're not really disclosing personal information, this is a bit overkill. So obviously make an assessment, and the board should make an assessment what is required in terms of a data protection plan, for example. Then you will have your usual indemnities in the contract for breaches and things like that. Again, that's another minefield, because if you're dealing with a company in Australia, that's probably okay, because it's easier to enforce. But if you're dealing with overseas entities, that makes it a lot harder, because not every country is favorable to litigation and things like that. So then you'll have to think about, are you dealing with a country that is easy to deal with, that has good economic ties with Australia, and so that if there's an issue, you basically can rely on the legal system in that country, essentially. And that's where indemnities are useful. There's no point drafting an indemnity if you can't really enforce it.
Yeah.
You want to also clarify in your contracts who owns the data, what happens to data at the other end.
This is the big
contract.
one I wanted to talk to you about. Yeah, this is the question, sorry to interrupt. This is the question that we get asked a hell of a lot in terms of people are collecting information and then they're passing it off for data analytics and usage. And I get asked this quite a bit, is who owns the data? And, it's a big question, because obviously data is not only as a protection perspective, but it's worth a lot of money now.
Yeah,
to a lot of
absolutely.
businesses.
Absolutely. In terms of who owns the data, often it's the entity that collected the data, but it's also in a way determined by contract. So if you have the raw data, often it's the collector, because that's the source. But if you have analytics that's performed on it, often the contract would determine who owns that information, and often it will still be the company that collected it if they drafted the correct contracts, essentially.
Right.
You wouldn't want to give away that information because, as you say, it's really valuable. Now, sometimes analytic companies like to say that they own anonymized data, and that's probably okay. But then again, you want to ensure that you understand how they're doing that. Is it really anonymized? Is it anonymized in the manner that the Privacy Act actually says it should be done? Or is it just what they say is anonymized? Right. So
Interesting, yeah. So, I mean, from my simplified perspective, I suppose the key thing is we receive all these, particularly when you sign up to things online or you're doing something a little bit more substantive in terms of, an agreement with a supplier. It's often or not, as business owners, we're all busy and all things like that. We don't have an in-house legal team or things like that. You get these things in, I've been and done it. It's getting better, but we've all been and done it. We just tick the box or sign the document and it's never read. So probably the lesson here is dig deep. I mean, that's one of the services that we're not providing legal advice, but we're saying, okay, well, we're particularly interested in regards to where this data is flowing, to give some guidance to say, okay, well, you should even be asking questions, because a lot of these companies are hugely vague. They're like, well, we collect the data and house it in our data centers. Where is the data center? For starters, how secure is that data center? So it's interesting. Just under the Privacy Act, from what I understand, it's in terms of a notifiable breach to the OAIC, companies over 3 million. Is that a requirement to report?
Generally, so generally it's an APP entity, and you're right. The rule of thumb is a turnover of 3 million or more. But not just that. So, for example, health service providers, you have to comply. Entities that deal in personal or trade in personal information, really, they'll need to comply. But the rule of thumb, 3 million, that's correct.
Yeah, right. And so let's walk through maybe not specific instances, but hypothetically speaking, you've tried to do all this, but in cases that you've seen where this has just gone off the rails, and you've got a client come to you and said, we've got a data protection issue, a cyber instance. Obviously the first thing is freak out, or someone's coming to them and suing them, or whatever that may be.
Yeah, exactly.
What's gone wrong with these? Like, what are is there themes, or is it very individual, or is it is it the due diligence? Is it just a lack of structure and process that they haven't put in place, months and years prior?
I don't think it's always necessarily a failure of due diligence. So, for example, the OI or AIC, that word is just the worst.
It's a shocker, isn't it?
The OAIC, they produce reports for each 6-month reporting period, and they talk about the number of breaches and how those breaches have occurred. And the latest report basically talked about the majority of attacks really being phishing or malicious activity, that sort of thing. So not necessarily a failure of due diligence or human error or system faults. A lot of it is malicious or criminal attacks. So I guess to answer your question, it's not really a failure of DD. Maybe it's a failure on the part of the data center or the service provider who have adequate cybersecurity systems or protections. Again, that's going to depend on a case-by-case basis, really. But you can imagine the things that go wrong is, there will be people who start pointing fingers instead of working collaboratively. I think that's where things go south really quickly.
Yeah.
where everyone's trying to protect their own back, essentially.
Particularly when there's a number of parties involved, as we said, all of a sudden you think that there's two parties involved, but then it all of a sudden expands to, two and three other suppliers and other countries, and it can get very nasty.
Yeah, and especially if you're dealing with a service provider where the breach occurs in the service provider systems, they have multiple clients. And so then you have multiple people who are competing for the right to do the right thing, essentially. Um, in that case, it's been interesting the way responses have come out from that situation. In some cases, where there's a multi-party breach, usually the MSP will manage all aspects of that data breach because it's probably in the best position to do so. And if that's the case, and if you're dealing with someone who probably has multiple clients across multiple countries, you probably want to ensure that your contracts are very clear about how that process is going to work and how involved you will be in that process and what say you have in that process as well. There are other cases where MSPs will basically push the responsibility for breaches to clients and say, all right, well, there's a breach, we've informed you, now you make an assessment about whether it's an eligible data breach, and then you make a report. Probably not a good idea on the service provider's perspective, really, because you're basically trying to wash your hands of your obligations under the Privacy Act. And if the other party doesn't report it and you don't report it, then you're pretty much both in trouble.
Yeah, well, that was one of the things I wanted to bring up today is that from some of the information we've shared in the last few days, there's some information that I don't know whether it's in legislation or what have you, but that essentially if you have a breach, where a service provider, a client has a breach or a supplier has a breach, and they don't want you to notify the OAIC, then you're still liable, right? That's correct?
You can be, yes.
Yeah. Okay. So I suppose again, the learning here, can't put your head in the sand and hope it goes away, right?
Yeah, exactly.
Yeah.
And everyone needs to take responsibility essentially because everyone's potentially liable.
Yeah, it's interesting. Talk us through cyber insurance, another area that we get asked about all the time. What's the and I understand you're coming from a legal perspective and not an insurance perspective, but what's the difference between professional indemnity and some of these cyber insurance policies? Are both required? Do they lean upon each other?
Are required, definitely. They do sort of cover different things. Professional indemnity really covers the services that you're providing and the standard of services you're providing, and negligence in that respect, essentially, and very, very broadly speaking. And I'm not an insurance lawyer, but broadly, that's what it does. Cybersecurity insurance, or sometimes it's called technological liability insurance, goes into more specific heads of losses, we call it. Things like loss modification to digital assets, cyber crime, cyber attacks, extortion, cyber extortion. Non-physical business interruptions caused by, say, network interruption and that sort of thing. So it sort of deals with different aspects. You definitely need both.
Right.
And the interesting thing is when you apply for cybersecurity insurance, firstly, you have to jump through a few hurdles, and they will require you to then prepare data protection plans, and they'll ask you a whole bunch of questions. So that process in itself will force a business to actually start taking the right steps, actually.
Yeah, we see that. I think it's been from our perspective, we've got a constant battle, Narin, and fair enough for businesses to try and lift their cyber posture. It's a battle because it's a bit like general insurance. It's like, well, do I actually need it? You're running the gauntlet. But what it does do for an organisation is it certainly forces the organisation to go, okay, well, we need these things in place. You just can't. I mean, you can tick the box, but and if you have a claim, they're certainly not going to provide coverage in the case of you ticking a box and not having the relevant protections in place. Mate, want to switch? That's all. I think it's absolutely interesting and it's absolutely vital information. So thank you. I want to switch a little bit. Another thing that we get asked about all the time is artificial intelligence. How the hell is that? I imagine, and everyone, I wouldn't say everyone, but a lot of people say, oh, that's going to change law forever. And, that bulk work and all that sort of stuff, that's a very outsider's perspective. Are you seeing it in happening in law? Is it changing the industry at all?
It is definitely changing it. I wouldn't say it's a wholesale change. It's definitely not going to suddenly get rid of lawyers and you're going to have a whole bunch of chatbots running around. That's not the case. Really, what we're seeing is it's becoming really useful as a tool for lawyers and law firms to actually leverage firstly, the information that law firms have built up over time, whether it's their knowledge library, their document library, things like that. It sort of speeds up that process because obviously you'd have the ability to pull information from various areas, combine it, produce an advice, for example, really quickly. The great thing about machine learning as well is, you have the ability to train it to, say, review contracts or review documents. So it's really a great tool to speed things up. And we use it as well, for example. So when we have contract reviews, we'll run it through a system. It'll pick out, within less than 5 minutes, all the things potentially there might be an issue from your client's perspective. I wouldn't say it's perfect, but it's probably as good as a junior lawyer. Yeah. And so what I think it's changing is how junior lawyers are starting to work, and the skill sets that they need, because they need to learn to know how to use this information. And senior lawyers need to learn how useful this information is and how to basically give the right feedback to junior lawyers. I think it's a win for both sides, both the clients and lawyers and junior lawyers, people coming into the industry. But it's not something I'd fully rely on at this point in time.
Does it do stuff like, and again, from an outsider's perspective, I know that if you've got a case before the courts, you, as a lawyer, you would be looking at other cases and other case law and all that sort of stuff. And I would imagine that would just take hours and hours and hours. Surely that's an area where AI can, you can give it a certain amount of prompts, go off and analyse previous cases and come back with information. Is that sort of stuff happening as yet?
Yeah, it's been happening for a while now, and there's some expert systems that will, be able to look at a case database and say, based on the current facts that you've given the system, your likelihood of success might be this or that. It does speed up some of that legal research process.
Right.
But the interesting thing about cases, I guess, is, one fact suddenly can change things. So it will help in building a case, but it's not going to tell you, you got a home run necessarily.
Yeah, right. Okay. Just it's a tool, right?
Yeah,
and probably one that's going to continue to get better and better over time, I would imagine.
It's really good with due diligence and things like that as well, because now there are systems out there where you've got multiple supplier contracts, or you're doing mergers and acquisitions, and you want to review a whole bunch of contracts for a particular clause, and say the clause might be a privacy clause, or it might be a change of control clause, or things like that. It can run over all these documents, something that would take tens of thousands of dollars, do it in a day potentially, and you get all this information back, a full analysis where everything's sort of sitting. So it is amazing that way. Yeah,
interesting. The only other comment I'd probably say on that is, we look after a number of legal firms, and I am interested. It's creeping in various areas, and I'm just reminding people that these AI platforms, people are feeding information into them, And I think it comes back to, again, where you're putting your data. People are sort of inadvertently going, wow, this is a powerful tool. And not just law, but it's, excuse me, in every area. They're putting in the information. I just remind people that, like, do you know where this information is going? Because there's very open source platforms where there's it's not what we refer to as a contained housing of AI, where it's reading a complete set of data that you've provided or given it a scope to provide and then contained back to you. A lot of these platforms, you're giving the information and now they're becoming sort of almost conversational. So not only are you giving it one prompt, but then it provides you information and then you're refining it or asking more questions. And in a lot of these cases, that's going out to other people and that they're retaining that information and using that to their advantage. Again, it's all in the terms and conditions. I suppose it comes back to no one reads it, right?
No one reads it, which is why when we use it, we basically strip out all personal information and amounts and all that sort of thing. So basically, you're just looking at a raw contract, which is really no different from just looking at a template document you pull online. So we sort of take those steps. And interestingly, I think the courts now have sort of caught up. Usually they're very slow to catch up with this sort of thing.
Oh, right.
But the Supreme Court of Victoria, for example, has released guidance saying if you've used AI in the preparation of your case for litigation, you need to disclose that. You need to disclose how you used it and the limits of it and all that.
Oh, interesting.
And that just recently came out, not very long ago. So now the courts know that people are starting to use those tools. Hopefully no one's silly enough to be like that lawyer in the US who chat GPT a case and the case didn't exist.
Whoops.
But I won't be surprised if someone does that.
Yeah, it's interesting. Well, that's just been hugely beneficial. I think that, the purpose of today's, I'd love to have you come back on at some stage and digest and go a little bit deeper on something, on some of these areas in the future. But today was really about, where's some of this risk lie, because we get asked about it a lot in our clients and potential clients and they're thinking about it. And I suppose the real lesson is just be aware of this stuff, right? I think that's a fair assumption is don't just click through the buttons. Don't, automatically think that it's going to be okay. Because
absolutely. I think that is the key takeaway. And I think you sort of made a very salient point earlier where you said, you need GI, general insurance. Right? And people now just take that as a given. You've got a house, you've got a factory, that's GI. We need to be in that mindset now that our IT systems, our personal information really is an asset that should be treated with the same respect as a factory or a plant of equipment and all things like that. So look at it that way. And if you shift your perspective in that manner, you would want to protect that as well. That on top of the fact that if there's an issue, you probably have fines and reputational damage. If your factory burns down, I don't think anyone really cares too much. Your customers might care.
That affects you.
Yeah,
it's and the only other thing that I would add, and it might be a good lead into how people can contact you and all those sorts of things, is another big trend we're seeing is not only getting asked, but we're also getting asked to provide, evidence of policy and audit for organisations. Where, I was speaking to someone this week, very small organisation, potential client. They're growing, but they're small, but they do custom consultancy in sort of the online space for really big organisations, thinking like Westpac and EY and these organisations. So you've got a really small entity dealing with these really big entities for a very custom piece of consultancy, which can happen. But these big entities are saying to some of these smaller people, well, where is your audit, your policy pack for cyber? Where is your cyber insurance? I'm talking sub 10 organisations even. So it's really coming, and people can't ignore it just from a doing business. Not forget about for the moment, you need it to protect yourself and you need cyber insurance. These organisations are coming, or the bigger organisations are looking at smaller organisations. You need to be at a sort of a posture of much bigger organisations. So we're seeing that coming. On that, obviously you do that sort of work and provide some advice and hopefully before the fact and not after the fact when things go wrong. But mate, how can people contact you and engage you in your services?
Yeah, so I mean, best is come through email. So being at ascenta.co. It's co, not .com.
Yep.
A lot of people get confused by that, and Ascenta is ASCENTI. Um, Otherwise, just through our website, we've got our phone numbers there. So Ascenta again.
Awesome. We'll link everything in the description, and I'm presuming that you take on clients countrywide and even internationally.
Countrywide and internationally.
Yeah, wonderful. Look, I can't thank you enough for coming on and providing some help and guidance and obviously a huge knowledge of this area. And as I said, we'd like to dive a bit deeper. We need to do this in small batches, Narin, because it can be a bit dry, but I
Yeah.
think that there's a yearning for information and just sort of it's sort of almost about, where do we start? So hugely appreciative and thanks for your time and hopefully we can talk soon.
No, thanks for having me. I think
Awesome.
that
Thank
was
you.
good. Thank you.
Good on you.
See ya.